Hi everyone, welcome to the Arum webinar on breathing space, or known as the debt respite scheme. I think we're just going to leave it maybe just 30 more seconds just to make sure we've got everyone, and then we'll kick off. Just a few more minutes. Um, good. So I think we'll start. So as I say, welcome everyone to the Arum webinar. So we're here today just to chat a little bit about the breathing space scheme that's due to launch in May, or is it formerly known as the debt respite scheme. So today I'm here with Dominic Penfold, who's a consultant at Arum. So Dominic, you spent the last 3 months sort of operationalizing the debt respite scheme or the breathing space scheme. And so today we're going to have a bit of a fun and talk a little bit about some of the complications and some of the challenges that have happened really around implementation, around the new legislation that's kind of coming through. So right from the very start, I think we wanted to take a couple of polls. And so I don't know if we can just put the first poll up just for the group here, which is just really around, how operationally ready do people feel around the breathing space scheme and the implementation of that that's due to launch in May. So we'll leave that up and I'll just do a quick introduction. So I say today here with Dominic Penfold, consultant at Arum, spent the last while, 3 months implementing the breathing space scheme and sort of the operationalization of that. Just a couple of housekeeping notes just as we start. So first off, obviously both of us are visible, and audible. Everyone else who's attended, and thanks very much for attending, can't be seen or heard. So we'll have a conversation. We are recording this session, so there'll be opportunity to maybe see some of it later on, but just so people are aware that it is being recorded and plans are to share it. If anyone in the audience really wants to interact, please feel free to do so. We want to try and make this an informal session as much as we can. We'll explain what we know. There's a moderator chat if you've got technical issues. Otherwise, just please use the Q&A tab on the right of your screen just to ask any questions, and we'll do our best to answer them. If we aren't able to answer all of the questions fully, we'll circulate any answers afterwards as well. So if we don't get to everyone, apologies, but we'll definitely circulate anything that we didn't get to. And if anyone wants to have follow-up sessions or explore the issues a little bit more, then obviously, of course, then any of us at Arum are really sort of happy to follow up with people on an individual basis as well. So that being said, I think I want to we just put the presentation up. We got the presentation. A little bit of background really in terms of what we're now going to talk about. I suppose there's a lot of discussion out there in the market. We just go a couple of pages on. A lot of discussion there around the breathing space scheme, and we know that there's breathing space is already in the market, particularly from a financial services point of view. But this is actually slightly different. So we're actually going to be talking about that there's legislation that's been passed and is due to go live in May, and it's actually technically called the Debt Respite Scheme, which is the Breathing Space Moratorium and Mental Health Crisis Moratorium. So it's new legislation that's gone through. So there's legislation, you can see it on the internet. It goes to multiple pages. It's going to be launched and it goes live in May. And so through the legislation, it applies not just to financial services, which the previous FCA breathing space did, but it also applies to other businesses as well. So, for example, utilities are applicable, local governments are applicable, and it's really around consumer legislation. So it's across a broad section of industries. It is different from the existing FCA regulations. So if you're in financial services, the FCA have currently got a consultation out now to really work out how do they combine this new legislation that's coming out with their existing legislation. So there's this new sort of like I suppose new regulations that are coming through and more change that's basically happening. But obviously this is going to be the rules and something we got to get ready for launching at the 4th of May. So as I say, so I introduced Dom now. So Dom's been working on some of the operationalization of this, and I think at a face value, when I've been reading the legislation going through it, it sounds very easy to say, but one of the things that we've been finding is being very difficult to actually operationalize in terms of actually creating the systems to do that. So on the next page here on the presentation, there's actually a sort of like a simplified graphic that we pulled together. And Dom, I don't know if you've got time, maybe just to quickly walk through it would be helpful, because you're being very close to the operationalization of it, and how that needs to get implemented. So Dom, do
Yes,
you want to
absolutely.
walk through it?
Yeah, absolutely, Chris. Thanks a lot. So this is quite different to the existing breathing space that we currently have within financial services. The existing breathing space, a customer would call up their bank, credit card company, and say that they're in financial difficulty and that they're going to talk to a debt advisor. And normally, you'd then put the customer onto a breathing space, which would then stop interest, fees and charges, stop contact, give the customer 30 days to talk to a debt advisor to understand their position, and then come forward with a debt management plan to deal with whatever debts they happen to have. This new scheme is different and is separate. And what will happen, the customer will generally go directly to a debt advisor. If the debt advisor thinks that it's the best course of action for the customer, they will set the customer up on this new moratorium. To do that, they submit the customer through a new portal that the insolvency service is creating. They'll load up the customer onto that and submit them for a moratorium. All of the customer's creditors, so that could be financial services, your current account, credit card, mortgage, as well as utilities and a number of other areas as well. Those companies will need to plug into the insolvency service register, and they will only get information about the moratorium through the debt advisor and then through that centralized register within the insolvency service portal. So it sort of creates a divide between the customer and the creditor. So you're not necessarily going to even be told that the customer's in financial difficulty or that they've gone to a debt advisor. All that's going to happen is you'll get a notification from the insolvency service register say you need to put this customer onto a moratorium. When you get told that you need to put this customer onto a moratorium, will normally be notified. There's a few different ways of being notified from the portal. The main two will be via email or via API. For day one, so by May the 4th, we're not expecting APIs to be available and ready. So most places are going to have to receive emails from the portal that say this customer is going on to a moratorium. The information that's held within there's mandatory information for any customer that gets placed onto a moratorium. And that will generally be the customer's name, address, and their date of birth. There's no guarantee, so that's the minimum information that you'll receive, and you'll need to identify the customer's accounts that you hold based off that. The customer's likely to tell the debt advisor, yes, I have a mortgage with this bank, a credit card with that bank, I owe this utility that, and that utility that. But there's no guarantee that we're going to get account numbers for all the accounts. We should have maybe a rough idea of the amount that that customer owes, but it's not guaranteed to be the exact amount, and it's not necessarily going to specify here's every single debt. You might just say, oh, I owe this particular bank 10 grand. So you'll get this notification. You might not have all of the information you need to identify the customer, but what you need to do is identify the customer based on their name, address, date of birth. Identify all the accounts that you hold for them. Any accounts that you can identify that you can confirm have been placed in the moratorium, you need to go and place on a moratorium. Any additional accounts that you then find, and there's an expectation that you will do a reasonable search for any additional accounts that weren't included in the moratorium, you need to then submit a notification back to the insolvency service register to say, we found these additional accounts, do you want these to be included within the moratorium? So there's a couple of hurdles there to start with. You first need to do a search for the accounts, and that's a reasonable search across your systems, which if you have a centralized customer system, that's not super complicated to do. But if you have multiple different host systems which hold multiple different products across multiple different brands on different systems, especially if they don't talk to each other, you need to find a centralized lookup function, some sort of centralized lookup functionality to identify all the holdings you have for that customer. So that could be automated through some form of lookup tool, that could be done manually by the operation, but you need to identify all the accounts that you hold for that customer. You then need to send the any additional accounts that haven't been included in the moratorium back to the debt advisor and ask if you want those to be placed on the moratorium. And then any accounts that you have identified then need to be placed on the moratorium. So moratorium itself will consist of collections contact suppression, so not sending any collections agents to the customer. You need to freeze interest, fees and charges, and that needs to be done by the day after you receive notification from the insolvency service portal. So if you get a notification from the portal at let's say 8 o'clock at night, you need to have frozen any interest, fees and charges that you would have applied to that debt by 1 minute past midnight. That's very, very quick that you need to respond. There is the option to retrospectively remove any interest, fees and charges that you incorrectly applied, but then we also need to ensure that there's the appropriate reporting and coverage to make sure that we are picking up any instances where we do charge interest, fees and charges incorrectly. The moratorium itself, there's two forms of moratorium. So there's a limited and an unlimited moratorium. Limited moratorium is a standard 60 days, and that's during which you have interest, fees and charges suppressed, as well as contact suppression. And then there's the unlimited moratorium, and that's where you'll have a moratorium submitted. It will not have an end date, and you're expected to leave the customer in that moratorium indefinitely. And that's for any customer that has been confirmed to be in a mental health crisis by a mental health practitioner who can sign off on that, and then the debt advisor and the mental health practitioner will leave them in that moratorium for however long the customer is within that mental health crisis. So there needs to be an ability to differentiate and hold the accounts within your systems to hold them for an indefinite period of time with that interest, fee and contact suppression. And there's slightly different rules as well when it comes to the debts within the moratorium. So for any unsecured debts, the expectation is that interest, fees and charges will be suppressed for the full product. Whereas if we have a secured debt, the expectation is only to suppress the interest on the arrears that have accrued up to that point within the when the customer is placed on the moratorium. So let's say you've got a mortgage, list two of your monthly payments, so that you're at £500, you're £1,000 in arrears, then have to freeze interest on that £1,000 of arrears. If the customer misses one of their mortgage payments during the moratorium, regulations do allow you to then start collections activity on that £500 that would have then accrued during that moratorium period. The expectation is that the moratorium isn't a payment holiday. The customer's arrears shouldn't increase in that time, which is why we're freezing the interest, but they are expected to maintain their mandatory payments. Within the regulations, the mandatory payments are broadly, for most places, it'll be most of the mortgage. That's the key thing to paying, and it's to maintain your mandatory payments. If a customer doesn't make their mandatory payments, you can advise the insolvency service that the customer isn't making them. You cannot remove the customer from the moratorium. You need to wait for the debt advisor to make a decision to whether to remove them. If it's for an unsecured debt, then they are not expected to continue making them, and our expectation is that there'll probably be some customers that make some payments, some that don't.
So Dom,
one of the
big issues that seems to be coming up here, as I understand it, is that you sort of lose that connection. If I'm sitting there as a company, I lose that
yeah.
connection, direct connection with the customers. I mean, what are some of the complications that have come from that? Because it seems, I mean, certainly the existing process, we tend to have lots of conversations with customers, and you sort of kept up to date, and it seems like it's almost
Yeah,
like it's much more sort of hands off a little bit.
it's very much so, and it should make things much simpler for the customer. The customer can
Mm,
go to a debt advisor. The debt advisor can um, group all their whatever debts they have together. They can sort of orchestrate it for the customer, so the customer's just talking to one person about their
mm,
situation and not having to call up lots of different people. So I think it's a big benefit to the customer. But the reality for most places, when you sort of operationalize this process, we're going to be told to move a customer to a new process and a new treatment, hold them there without the, having had that conversation with the customer, which is
mm,
fine if they're just going through your mainstream collections processes. But if you've already agreed a treatment with the customer, the way most of the collection systems will work and the host systems, well, you'll have to move them off that treatment.
mm,
So one of the big headaches that we've come across is um, current accounts and balance reduction plans. So if you've got a DCA account and you've got a reduced debt limit, where you'd expect where you're reducing the customer's overdraft limit every month to bring them back in line over time into their overdraft, the expectation would be that you then cancel that balance reduction plan. Cancel that, the limit will default to their lower limit. Generally, that's how most of the post systems uphold that type of plan. And you then lock the customer out of their bank account.
mm.
So that's a one of the big pain points is when you start cancelling a treatment you've already agreed. If you've agreed with the customer that they can, let's say, have a 2-month payment holiday on their mortgage, moves into the moratorium, we're then going to start expecting the customer to be making their CMT.
And if I understand it, the only way to sort of get included back is they then have to go back to the debt advice to then make those changes, right? So you can't just talk with the customer directly, even though they might call you. You have to go back
Yeah,
almost like round this loop to be able
yeah,
to fix it.
yes, exactly. And we're expecting to see. I think repayment plans are a big headache. We're expecting to see customers where we will have to cancel their repayment plans to move them into this new moratorium treatment.
Mm,
And if the customer's gone to a debt advisor, we're giving them time to finances, trying to give them a bit of breathing space. So not expecting those payments is probably the best thing for the customer. But if you've agreed reduced payments on your mortgage, for instance, then you're expecting again.
mm,
Um, and the expectation is that if we just go by our BAU automated processing, if we cancel a plan, that's going to trigger a letter to the customer that says, by the way, Mr. Customer, we've cancelled your plan because you told us to. And um, those plan cancellation letters could have collections style wording in them. So say, you cancelled your plan. If you don't make payment, your arrears will get worse. Please contact us, that sort of stuff.
mm.
Regulations say we can't do that. So it might be that we have to, the BAU plan cancellation letters, as an example, might need to be amended before May the 4th.
And what's been the view around so regulatory letters? Certainly in in many industries you have regulatory collections letters. So for example, Consumer Credit Act letters as an example, which have to go out, and then you have sort of collection letters that are going out too. I mean, how do you reconcile two? Is it both that have to stop, or is it just the collections letter, the collections communication?
Yeah. So any regulatory letters are expected to continue.
Mm,
There is going to be a review of CONC, MCOB, and some of the other regulations to bring them in line with this new moratorium regulation. So there is likely to be changes that we see over the coming months to bring those other regulations in line. So that is a moving target to a certain degree, but we are expected to continue those regulations.
yeah. And what's your view on the review that's going on? Do you think because at the moment it seems sort of at least initially like you could almost have two sets of breathing space. So you could have the initial breathing space that comes on, and then you could go into this like the debt respite scheme, which is the second set of
Yeah,
breathing space. It's like it's two, and you could almost like double up. Do you think
yeah.
the FCA review will sort of remove one of those and sort of harmonise it? Is there been a view from what you've heard around what will happen there, or?
Um, I'm really not sure. I think we will see a doubling up, at least at first.
Mm.
Whether they change it, we'll have to wait and see. But the
Mm.
expectation is that anywhere in financial services where we have breathing space already, that will probably continue tandem. So in theory, you could have a customer go onto the into their sort of breathing space for 30 days or maybe even 60 days, go to a debt advisor, get onto the moratorium, that'll last 60 days. So you could have a customer that's had no contact, no interest, no fees for 90 days,
Mm.
120 days, then get out of the process.
That's,
And that actually leads on to one of the other complications with this, which is the exit from the process. So after the 60 days, if there's no debt management plan agreed, then what do you do with the account? If you've
mm.
not had any contact with your customer for days, 90 days, where are they going to go? If you just resegment your account and it's an unsecured account, that's going to run straight into your charge off processes if you charge off after 3 or 4 cycles. So you
Mm.
could be sending a customer going into this, could go through this, not make any payments, continue to cycle, then go straight to charge off. Or if it's a mortgage and if not a mortgage, you then might start becoming litigation qualifying if you hit your internal rules for that and then start going down legal proceedings,
Mm.
having not talked to the customer for an extended period of time.
Yeah. And what about other kind of edge cases that always cause a complication? So things like joint accounts and other linked accounts and those kind of things. I mean,
Yeah,
how do you start thinking about those? Because one of the parties might have gone through and been going through like a moratorium and going through debt advice, with the other one maybe not. I mean, what's
yeah,
how are you thinking about those?
yeah. There's a lot of edge cases. Joint accounts are really difficult. The hope is that 80-90% of cases that go through will have good information. They'll be easy to match. You'll be able to put them on, and you're not going to be cancelling treatments or that sort of stuff. But it's all those edge cases where you've got to plan out all these different routes and all the different how it's going to interact with all your BAU processing today. The joint accounts are difficult, so need to offer the same protections to the joint customer for any of the joint debts. If there's a joint customer to the party that has a moratorium that has sole accounts, those won't be included, but any joint account will be included, can be included.
Okay.
So it starts to get complicated if you've got, say, a joint debt, one customer has passed away, and so the debt is in your systems, is in your deceased process with your deceased team, then the other customer goes to the moratorium. You have to put them into the moratorium, but what happens if you move them that account away from your deceased process? So what if
Mm.
you accidentally resegment, it goes back into mainstream collections and it's again?
Yeah. So that sounds like there's going to be issues around making sure you put it in properly, and then you have right levels of control and really sort of thought through the
Yeah,
processes in some detail. Yeah. And one of the pieces that really struck me when you're sort of explaining it is just that whole piece around matching and getting the information and matching that information through. I mean,
yeah.
how difficult is that? I mean, have you seen file formats? I mean, how ready is the insolvency service today? I mean, how much of this is there now? You can sort of get ahead with it. How much of it is unknown, and you've got to build contingency processes for?
Yeah, so when we started working on this about 3 months ago, we started to design on the assumption we'd have APIs to pull the information from the
Mm.
portal. We were told a month or so ago that was probably not going to be ready in time, so we're having to build processes around handling emails. The email format has been standardized, so you can use a level of RPA to stuck that information out to then
Mm.
perform your searches. There's a number of questions around doing searches. So if you're a big organization, you've got multiple brands, you've got multiple different host systems, all that sort of stuff, you've got a complicated systems architecture, then doing the search could be quite difficult. Are you expected to do a search at your legal entity level, at your brand level? If it's a big organization, the umbrella group level? That
Okay.
that's definitely a headache. One of the things to consider, um, if you want to understand the complexity of the search, is what do you do today for DSAR? or PPI claims. So if you walk through the DSAR process that you do at the moment, when someone requests all the information that you have on them, how long does that take you to do? Where do you have to go to pull that information out to understand all the holdings you have for that customer? We're going to have to go through a very, very similar process to do that for the moratorium requests and the moratorium lookups, except that needs to be really quick. So we're looking at the moment to try and have that done in 2, 3, 4 days, that sort of thing. Most of it being automated with some manual work.
Yeah, and I suppose the more systems you have, the more complicated it becomes. The more products you have, maybe a lot of people have different products and different systems. I mean, all of that has to be matched, isn't it? And what
Absolutely.
about the whole idea around, so I suppose, next day, it needs to be done by midnight the next day. I mean, there was some discussion, I think, earlier on around, is that next business day? Is that next working day? And so, I mean, so things like weekend processing can be often be an issue.
Yeah.
I mean, is there clarity around that? I suppose is one of the questions. But then, if there's not, what are the workarounds for that? Or in terms of the thinking, that what have you seen there?
Yeah, so it's next day. It's not next working day. So sort of the worst case scenario that we sort of worked through is most systems that we work with are going to be batch based, and we don't run batches every day. We'll probably run them Monday to Friday. Some organisations will run Monday to Saturday. But if your BAU batch processing is Monday to Friday, we're expecting debt advisors to work on the weekends. So what if you get something in on a Saturday? Or if you kick your batch off at 7 o'clock, you expect most of the debt advisors to probably work till 8. So we could get notifications in at 8 o'clock. What happens if you miss that deadline? So most of it, if you get stuff coming in Monday to Friday, it's probably manageable. But when we're getting stuff in later in the evenings or over the weekend, that's when it starts to get more complicated. The expectation is that we freeze all interest and charges by the next day, but we can retrospectively remove any interest, fees, and charges that we incorrectly apply. So,
and you want to do that
could apply stuff late.
Because of
the quicker we do it, then the less rework has to be done and manual interaction by the operation. So the less, the more that we can automate, the better. Obviously, the contact suppression, I think, is where it gets more tricky. We need to stop contact, which you can do if you're sending collections letters from. If you've instructed a third party, you need to stop that third party taking action.
Yeah.
And that's where it starts to get complicated. If you get an email from the insolvency service, you then need to search for the customer. You then need to update your internal systems. They don't talk to this customer. You then need to get that message to a third party. The third party then needs to read that message and do something about it.
So this is like if you sent the accounts out to a DCA or even I suppose debt sale to a certain extent, if people have just gone back to the originating creditor, then all that needs to cascade through.
It all needs to cascade through. If it's any sold accounts, if a sold account is put onto a moratorium, you need to identify that you've sold it and then respond to the insolvency service and say, we have sold this account and this is who we've sold it to. And there's also an expectation that you might need to tell whoever you've sold it to that account is placed on a moratorium.
Okay. And
sorry, Chris. I think there's one more point worth pulling out there. We are expecting to have cases where there's legal action taking place, particularly around repossessions. In theory, to get a customer request to go onto a moratorium, and you get the notification through on, say, a Wednesday, and you're planning on repossessing their property on the Thursday. And you have to stop that repossession. Even though you've had the court order, it's all organised, you have to stop that repossession. So there also needs to be a process to pick up the fact that he key cases, for instance, legal action, that you stop it and you stop it quick.
Mm. Okay, so a lot of this stuff is coming down to almost like the operationalization of it, as I was saying earlier, as much as it's like
Yeah,
it's one thing to say it, but then it's another thing to actually do it and thinking through the ramifications of it. The one complexity that really came up though was around, I suppose, this idea around the moratorium exists on the accounts that are included in the moratorium, and any new arrears then gets collected on. That was true for not just mortgages, but also true in certainly in local councils and sort of and those kind of areas as well.
yeah,
Has there been how's that been thought about? Because that could add quite a bit of complexity because you essentially have to separate the accounts.
yeah. You do. It's really complex. Firstly, can your systems handle that? Is whichever host system you have that holds the account, are you able to split out the arrears from the balance? Are you then
Mm,
able to split out the interest application from the balance? Then, if you got two arrears pots, one for moratorium arrears, one for arrears accrued after the moratorium, and you
mm,
split those out and then charge interest and collect on one and not the other.
mm,
My personal view is if a customer's in financial difficulty and they've gone to a debt advisor and are trying to work out their situation, it's a pretty poor customer journey to freeze collections, activity, and interest on some arrears, but not the other arrears that they're accruing
yeah.
because assuming they can't afford to pay.
Mm,
And then it gets really complicated if you're going to say, well, I'm not going to collect on this, but I am going to collect on that.
yeah. And there are a few questions just coming through now. One of them was around front loading interest. So a lot of interest could be front loaded. Have you come across that in terms of? And we're not going to give a legal opinion on here at all because that's we want to talk about the operationalization piece. But have you seen treatment around that, around whether that needs to be refunded or
Yeah. So I've not worked as closely with that. It's definitely something that you need a view from your legal team on. The
mm,
If you have insurance, hence have front-loaded interest on that. Insurance is quite an interesting one. So if you offer insurance, for instance, if you're a financial organisation, you do mortgages, you might also sell insurance like property insurance
mm,
alongside it. If you pay that insurance monthly, that's treated as a credit agreement. So it also then starts to get complicated. And one of the other things as well, if you're offering insurance, what if it's towards the end of the term and the customer's going to tick over into and it's tick over into their renewal period? If they're not making payments, should you cancel their insurance? Should you not? Should you allow them to continue on to it? Are you going to offer the same protections if they're not paying? There's
that's
a whole
another edge
load
case.
of, yeah, another edge case.
Mm,
And that's where it gets complicated. The happy path is relatively straightforward. There's all these difficulties and nuances that start to come out when you actually map it through, and you start to think about all the different ways it can start to get more complicated, especially by the fact that you're not talking to the customer. So you can't tell
mm,
the customer, by the way, I'm going to cancel this agreement that we previously had. I'm going to
mm,
move you here, I'm going to move you there. By the way, if you don't make payments for 2 months, I'm probably going to close your account. You're not
mm,
having that sort of a conversation with them. There's also quite a lot of onus on the debt advisors, not only to capture the information that's needed when they first submit the moratorium requests, so that the creditors can do an appropriate search and identify the accounts, but also to make sure that the customers are aware of the implications of what happens when they go into the process.
yeah. So, for example, your current account or your overdraft or your credit card or those kind of things.
Yeah.
Um,
So for credit cards, you're going to block spend.
mm. And I think you'd mentioned
There's an
before that
expect
there was some capability to allow some emergency spend, wasn't there? But it was only up to a limit, wasn't it?
Yeah, so the expectation is that you should offer customers up to a customer in a moratorium should be allowed up to £500 of additional lending across
Mm,
all their products total. Now,
mm,
obviously, if you've got credit cards with multiple different people, in theory, you could do 500 on each one and they wouldn't know.
mm,
But there should be that expectation they can have that emergency
yeah.
spend. So if you're going to, for instance, block a card, you need to block it in a certain way so that you can allow spend.
Mm. So I'm just looking through the questions here. So there's a specific question around, and this has come up before, around, who's this applicable for? So does it include sole traders? Does it include businesses? Does it include, or is it just consumers? I mean, I think what we'd seen is this is a consumer legislation, right? From the guidance that we've seen.
It is, yes. It can pull up the exact wording. So there's wording in the regulations and in guidance the Insolvency Service has produced. There's guidance for creditors and guidance for debt advisors as to how to interpret the regulations. I would say if you anyone that has to deal with these regulations, you should read the regulation. It's written like a regulation, but the creditor guidance and the debt advisor guidance are super useful. They really explain what's needed. In terms of businesses, the moratorium will apply. So some business debts also qualify for a moratorium. Business debts do not qualify if the debt relates solely to the business rather than your client personally. So if it's, again, that's all sort of laid out in the creditor guidance.
Yeah, so I think it was sole traders potentially could be included, but it was only if they didn't claim for VAT. So they claim for VAT, then they wouldn't. So there's some nuances, if I remember, just a little bit around that. So and then one last question that's sort of come through, which was so accounts have been placed on hold, and then you realise that you've got older accounts on breathing space. So do those need to be placed on hold as well? Do they need to also be placed in the moratorium too? So I think that's a kind of question around matching, and then how do you link them together? And then do you all put them into the same moratorium? And does it have the same time limit, or does the clock start ticking again?
Yeah. So there's a few points there. So you should only put an account into the moratorium if you've been expressly told to put that account into the moratorium. If you've got a customer and they have, let's say, a card and a loan, as an example, and you've been told to put the card on the moratorium but not the loan, then you can leave the loan where it is. There's a secondary treatment question around what do you do if you've got an associated account, so a customer with multiple accounts, some are in the moratorium, some aren't. You could choose to leave them where they are. You could choose to put them on your own internal breathing space hold that you already have to also provide interest fee and charge suppression and contact suppression. It's really a decision for obviously the teams that design your treatments and your credit risk.
So what happens if a customer's claimed one of their accounts onto the moratorium? You identify the other one, which they haven't identified. Do you have to go back to the insolvency service and say, look, this one needs to go back on, and then the customer then needs to choose whether to put it in the moratorium or not?
Yeah, one of the things that would have been really useful would have been in the information you get from the insolvency service, a full breakdown of all the debts that the debt advisor had considered with the customer. So it might be that the debt advisor has had a look and said, right, well, you've got a mortgage, you've got these other debts. We've agreed, say, a 2-month payment holiday with your mortgage provider, so we won't put that in because you've got a payment holiday. The others will put into the moratorium.
And
but you then still have to find the mortgage, say, do you want that mortgage put in? They'd then come back and say no.
And that doesn't necessarily change you. So if it's not included in the moratorium, it doesn't actually prevent you from then. Obviously, that's a key piece of information from a risk point of view to then take different treatment paths on what remains as well. So I suppose that's another nuance that might come through as well.
Yeah. So you definitely want to have the sort of flags to say this customer's gone into a moratorium, then sort of percolate down to your credit risk systems, your decisioning systems, your additional lending platforms, all that sort of stuff. So there's a whole load of additional lending choices that can back of it.
So I suppose that's quite important to think about in terms of the implementation of it, is making sure you're capturing some of that, and then that can be then used in downstream decisions as well, or wider credit risk type decisions as well.
Absolutely, yes. you brought up before the start and end dates of the moratorium, and this is also worth pointing out. So when you get told the customer's going on to a moratorium, you'll either get an end date or you won't. If you have an end date, then it's going to be 60 days from the start of the moratorium. If you then add additional debts, your end date stays the same. The start date for that other additional debt coming in obviously just comes forward, so that debt has less protection time overall. Right. You don't need to backdate any interest fee or charge suppression from before that additional debt was added in. Okay. So you're not having to do a whole load of rework to then remove interest you might have applied before it came on.
But the end date's still the same.
That is quite helpful.
Yeah, so the end date's still the same, but it's as of the point that it gets included, it goes up till the end date of the moratorium.
Yeah.
Okay. Exactly. And there was limits on the number of moratoriums you can have as in a year. Just run through that.
Yeah. So a customers allowed one a year, up to one a year, unless they're in a mental health crisis, in which case they can have any as they want.
Yeah.
What could happen is you get a joint debt, and one customer on the joint debt goes into a moratorium, gets their 60 days, and the other customer from that joint debt goes in, then that debt gets another 60. So you could see that happening, and because it's a different customer, you have to provide that protection. But again, bit of an edge case.
Yeah. And maybe a last question, and I want to put up just the final poll to feel what people think. So thanks to everyone who's listening in, just in terms of the questions. We had some great questions here. So just around credit bureau reporting, how's that to be treated? Because obviously that's a big part of what we do as well.
Yeah. So at the moment, that should stay the same. We don't need to be advising that customers are in the moratorium or sending any of that information in. So there shouldn't be any changes. We don't know if that's going to change going forwards. This part of the legislation is sort of part one of the legislation. So this is providing the moratorium protections. We're expecting new legislation to come in probably in the next year or so that's then going to start looking at bringing in sort of long-term protections around a statutory debt repayment plan. So this will be something that sort of probably mirrors the DAS scheme, which is in Scotland. These new regulations apply to England and Wales only, because Scotland already has the DAS scheme, but we're expecting there to be new repayment plans that will come in that are sort of mandated from the government. We're expecting medium long-term protection, 5+ years possibly. We don't have any of the details on that, but introducing this breathing space isn't going to be the end of the process. There's then going to be statutory debt repayment plans to consider as well.
Yeah. Okay. So just for everyone who's listening in, we just put up the end of webinar poll just to see how people sort of feel before and after the conversation we've had. It was 46% of people thought they were getting ready and would be fine as we started. It'd be good to just see if people just want to quickly vote, just see how they feel after this conversation. I mean, Dom, certainly, I mean, I've learned a huge amount over the last little while about this, and I've learned a lot of it from yourself in terms of like the details around it, and it really did just feel to me as if this was almost like a bit of an extension of really what we had before, certainly working in financial services.
Yeah.
But as you sort of talk through it, it gets into it just starts to snowball in terms of getting more and more complicated in terms of the operationalization of it, really.
Sorry, yeah, I was going to say, yeah, you're absolutely right, and there's no way you can just stick your customers onto the existing 30-day breathing space process you already have. You will have to create a new process, split these accounts out, and hold them separately. There's really no way around that. There's logging into the insolvency service portal, which will be a new portal. You need to do that creditor search to identify customer based off potentially limited information, identify all their accounts, freeze interest and charges, which for something like a mortgage, you might not have that functionality in the host system today. Same with if you've got a secured loan, might not be in the functionality in the host system today. So there's a whole bunch of stuff that's going to be completely different. The spirit of what it's trying to do is similar, but they are very separate processes.
Well, I know it's been, Dom, I know it's been like 3 months of your life, I suppose, just going through this, and I really appreciate you sort of, making the time today and sort of explaining it in more detail. So very much, an expert in terms of the operationalization of it. And I hope, so thanks very much. And I hope everyone who joined us today found that useful. I mean, the poll results, just if we close the poll now, I mean, the poll is looking like it's, probably a majority feel like they're still getting ready, and it should be fine, which I think is interesting. I think sort of following this, which, so hopefully it was useful for people just to explore some of the issues, explore some of the complications. I know there's still quite a bit to do depending on the complexities of the systems, but I hope people found it useful. The graphic that we showed, we've got this white paper which is on the screen now, and so the graphics included within there. So we'll send that out to everyone who's been on the webinar today. But obviously, if anyone wants more details or just wants to explore the issue further, either with Dom, myself, or anyone with the in the Arum team, please just don't hesitate to give us a call or contact us. We'll be happy to chat, obviously, a little bit more around that. Last off, say it is going to be recorded, so you'll see some information that comes out around the actual video itself, and we'll also send out a survey as well. So if you just help us just by giving your feedback, that'd be perfect, because that just helps us get better for next time. So we've had a bit of a different format this time, so hopefully it was interesting for folks. So Dom, thanks very much, and I think we're going to end the webinar there. Thanks very much, everyone.